let's go on the record on cause number DC 23-10054, Petro Hunt LLC versus Mendesa Consulting LLC. Council, make your appearances.
Your Honor, this is Reese Rondon and Dominique Delgado from Hall Mains Lugren for Petro Hunt, as well as our co-counsel Peyton McAllister.
Ryan Martin for defendant Kingpin Well Service.
And good afternoon, Judge. Kevin Duddleston for defendant Mendesa Consulting.
Okay, let's proceed.
Yes, Your Honor. Defendant Kingpin Service, in accordance with their original answer, filed a motion to transfer venue. I think it's pretty straightforward. I think there's a little bit of gamesmanship going on. This lawsuit, two defendants are involved. We have Mendesa Consulting LLC, as well as Kingpin Well Service. Kingpin Well Service is not a Texas defendant citizen. It relates to an oil field pollution event in North Dakota. Initially, the lawsuit filed, or the first amended petition, I think is what we're going to be basing a lot of the arguments on today, sued Kingpin Well Service as well as Mendesa Consulting. In their venue allegations, Your Honor, they specifically alleged that the first three general venue provisions did not apply. And I think that's important because, Your Honor, when defendants
I've read all of this. I have to admit, I'm not exactly following the response on this. So maybe explain to me a little bit more about the facts of what exactly happened. There was a pipeline blowout in what, North Dakota or South Dakota, is that right?
Yes, Your Honor, North Dakota.
And so what is this lawsuit about?
This is about that. This is exactly about that, Your Honor.
And how do we have, I guess, jurisdiction in Texas?
So Mendesa Consulting LLC is what we'd call like the company man. He was the man on site. He's one of the defendants in this case. And initially, there was an allegation that he did not have a principal place of business in Texas. And so, defendants, we were looking to remove it to federal court. However, upon investigating, it appears as though Mendesa Consulting LLC has a principal place of business in Hood County. Plaintiff's first amended petition, which is still on file, makes the allegation that they have no principal place of business in Texas. They have not fixed that. And yet in their response, they have now admitted that Mendesa Consulting, and there is an attorney here, I believe, on behalf of Mendesa Consulting as well, Mr. Duddleston, they've now admitted in their response that, okay, yeah, no, you're right when you allege that in your affirmative defense that Mendesa Consulting has a principal place of business in Hood County, but we still think venue's proper in Dallas County. And so, Your Honor,
what exactly, I guess I'm not clear. What exactly happened in Dallas County?
No, I mean, nothing, Your Honor. That's if you go to our nothing. And if you go to their allegations, there's no allegations against my client in Dallas County. There's no allegations against Mendesa Consulting in Dallas County. Petro Hunt is headquartered in Dallas County, and they make some vague allegations that because work orders were being required to be submitted to Dallas County and or payments came from.
What are the defendants?
No, Your Honor, they're the plaintiff. And in their allegation, they specifically said that Dallas was a proper venue because 1, 2, and 3 did not apply. However, they have now admitted that Mendesa Consulting has a principal place of business and that it should apply and be in Hood County. I mean, Your Honor, yes. I mean, it's nothing under the rules allows them to maintain venue in Dallas County against an out-of-state defendant and against an in-state defendant whose sole connection is Hood County, Texas.
Okay. Yeah. I mean, I was reading this, so I guess I want to hear from the plaintiff then. What exactly happened in Dallas County? Who's here? Someone speaking?
Peyton, you may be on mute.
Oh, let's see.
There
Can
you
you guys
go.
hear me now? Okay.
Yeah.
What actually happened in Dallas is the creation of the contract is what happened. Payments were sent to Dallas, but that's not necessarily why we were sued in Dallas. Defendant wants this case to be moved to Hood County because they claim nothing happened in Dallas, but nothing happened in Hood County either. Nothing more, actually less.
But isn't the defendant located in Hood County?
Yes, but the defendant that is located in Hood County waived their venue objection.
Your Honor, I represent Medessa. Your Honor, I can speak to that.
Go ahead.
The Texas Civil Practice and Remedies Code, section 15.0641 specifically says, and I quote, "In a suit in which two or more defendants are joined, any action or omission by one defendant in relation to venue, including a waiver of venue by one defendant, does not operate to impair or diminish the right of any other defendant to properly challenge venue." So then you revert back to section 15.002, the general venue provisions. They don't meet any of them. The challenge is correct. We don't have the ability to waive it on behalf of our co-defendant.
And Your Honor, again, going back to a little bit of gamemanship, there was initially an agreement to the motion to transfer venue that was only then withdrawn once Medessa filed an answer to the lawsuit. And so that's also why there's such a delay between the answer, the motion, and then ultimately get it set for a hearing. There was an agreement, there was a proposed order circulated per that agreement, and then Medessa answered, and then all of a sudden there was a 2 to 3 week delay saying, let us please review this. And then the official response that came down and said, no, we can no longer agree to this.
Your Honor,
Plaintiff-
this is Reese
Oh,
Rondon,
sorry.
plaintiffs. I guess I'm getting accused of gamesmanship. So if, with your permission, I'd like to respond to that.
Sure.
So we served both defendants. Mr. Duddleston's client, we had problem serving. When we filed the lawsuit, we did not think that they had a principal place of business in Texas. We served Mr. Martin's client first, Kingpin, and then they answered, and they asserted a venue argument. So he and I, before Mr. Duddleston answered, and Mr. Duddleston does cite correct statements of law, correct propositions, but he didn't answer your question. He did waive venue. I mean, I don't think that's a question. His answer does not have a motion to transfer venue. In any case, Mr. Martin and I discussed Dallas and Hood County. And I said, well, I've seen your motion to transfer venue, and from what I know so far, it looks pretty good. But can you agree to Dallas? We talked about it. He couldn't. And, we talked about it, and I didn't hear back. Mr. Duddleston then answered, his client, it seems, has a place in in Hood County, but he didn't challenge venue. He didn't challenge venue on the grounds that his client apparently has. Once that happened, that's when I got the agreed order that said, oh, by the way, can we close the loop on this? And I said, well, now that the world has changed, because to me, it seems like the party who had the venue argument waived their own argument. I said, we have to look at it. And when we looked at it, we determined that we still had an argument to keep Dallas. So I disagree that there was an agreement. I know that we were talking about an agreement, but I didn't get a proposed agreed order until after Mr. Duddleston waived his venue argument. And our argument is simply that Kingpin didn't have that venue argument because they don't have a place of business in Texas. So
They've cited to, did you say 15.641? Is that what you said?
That's correct, Your Honor. And I agree with what he's saying. My client has not asserted the venue challenge, Your Honor. We're sort of like a bystander in this. I'm just simply pointing out, I don't have the ability, nor does my client have the ability to waive the venue challenge on behalf of Mr. Martin's client.
Just technically, so we're all on the same page, I think it's 15.0641. Is that correct?
That is
Yes,
correct.
Your Honor, and that's
Okay.
cited in our reply.
Okay, sorry. So under 15.0641, it says in a suit in which two or more defendants are joined, any action or omission by one defendant in relationship to venue, including waiver of venue by one defendant, does not operate to impair or diminish the right of any other defendant to properly challenge venue. So how do you, Mr. Rondon or Ms. McAllister, how do you circumvent that particular
Right.
provision?
We agree that just because Medessa waived their venue argument, it doesn't mean that Kingpin can't bring a venue argument. Our argument is that Kingpin needs to bring their own facts related to themselves and not the facts related to Medessa. They can't bring the argument that Medessa has waived now. They can bring their own argument due to their own facts. If you read the motion to transfer, the allegation is, well, there is no real, sorry, let me rephrase. They claim that it's not proper in Dallas because Medessa has a principal place of business in Hood County. That's it. There's no facts related to Kingpin that make Hood County proper venue.
I guess what I'm confused about is how is venue, I mean, and let me say this, that in the vast majority, I'm not the type who wants to get rid of cases necessarily based on venue. I respect the plaintiff's right to choose their own venue. I just don't see how venue is appropriate in Dallas. Like what? There's none of the defendants are located in Dallas. The cause of action didn't accrue in Dallas. So what is how would venue be appropriate here?
Your
I guess
Honor,
you could argue that
if we had sued Kingpin on their own, there's no question that Dallas would be a proper venue. Because they don't have a principal place of business in Texas. And so Section 1 doesn't apply. Section 2 doesn't apply on its own terms. And Section 3 says we default to the plaintiff's place of business. So our argument is that as to Kingpin, the third section of that provision applies as they don't have a principal place of business in Texas. Section 2 doesn't apply, so we default to the plaintiff. Medessa, though, did have apparently a proper argument under the very first section of that provision. They waived it. So our argument is not that Medessa waived Kingpin's argument, it's that they waived their own argument. Kingpin didn't have this argument because we believe the first section is defendant specific, not case specific.
And Your Honor, just to, we would be able to remove this case to federal court, but for defendant Medessa. So they are saying, hey, Kingpin, we sue you in state court. You have to be sued in state court because we have a non-diverse defendant, Medessa. Oh, but by the way, we're keeping him in the case, but you also don't get to object to venue. Your Honor, that's it's an impossible standard that they are not able to cite to Texas case law with any support that they are anchoring my client in state court with the defendant and not a proper venue, and then saying, oh, by that way, that defendant we're anchoring with waived all of your venue arguments and we get to play ball in our home county. It goes against the entire judicial process of venue and state court and federal court and diversity jurisdiction, and to haul.
I don't see how diversity jurisdiction applies. This is simply, this motion in particular is just about what county is.
If Medessa, he just said that take Medessa out of the question is exactly what he said. He said, we don't get to rely upon Medessa for venue. And our point being, you can't remove Medessa from the equation, because if we remove Medessa from the equation, we're in federal court and none of this matters. So Medessa has to be a factor into this equation. And the factor is their principal place of business is in Hood County.
Since Medessa did not object, we have established proper venue as to Medessa. We're suing Kingpin out of the same occurrence, same transaction.
So I get it a little bit more.
15.5.
So what you're saying is 15.02 A4, if Medessa was not a party. So A1 says in the county in which all or substantial part of the events, omissions are given right as a claim, that doesn't apply. In the county of the defendant's resident at the time the cause of action accrued, defendant is a natural person. Or 3, in the county of the defendant's principal office in the state, defendant is not a natural person. So at least I understand your argument now. Okay, so what about in this situation? Has anyone looked at cases related to 15.0641? What does that really mean in a situation like this?
Your Honor, we didn't find any case specifically on point. We would have
We
cited
did
it.
look.
I think that's true for everybody.
I would agree with that, Your Honor. I think that's true for everyone. I couldn't find this exact scenario.
How about any cases that interpret 15.002 A4?
Only that it only applies if the first 3 don't apply, Your Honor, and that's I think the
But
crux
does
of
it have to be the defendant that's asserting venue that it doesn't apply to?
again, Your Honor, I'm not able to find any case specific, answers to that question. I think the court has now found the crux of it. They
Yes.
believe it applies to defendants individually. Again, we believe it applies to defendants as a whole, because again, under this scenario, to say that, because it also flies in the face of 15.0641, which is, if you're saying it applies in defendants individually, then there would be no necessity for the section that says, hey, one defendant can't waive another defendant's venue arguments.
And
At
our
the ver-
argument would be that that's true. They just have to bring their own facts for their objection. I mean, we're not saying venue can't be proper in multiple places, but if it is, then plaintiff gets to pick the proper venue. And we believe that we did.
But with Medissa as a defendant, venue is not proper in Dallas County. I think everyone agrees that.
Until they didn't object to venue. And so now it is proper as to Medissa.
So because they waived it, it now affects affects Kingpin, which goes
Well,
against
if you look at
exactly what the rule says.
15.005, then it says that if you establish proper venue to one defendant, if you have claims arising from the same transaction and occurrence, then venue is also proper to those defendants. So yes.
Yeah, this is an interesting issue. Now that I kind of get what you're arguing.
Your Honor, this is Reese Rondoni again. It is a tricky one. I would agree. I think that the way we analyzed it, though, is if we had done this serially, either sued Medissa first and they waived, and then we brought in Kingpin, or if we had brought in Kingpin, they wouldn't have had this argument to begin with. We brought them in together, and I'm not sure that should be a reason to change the calculus. You may disagree, Your Honor, and that would be it. I mean, obviously, but it's not a clean cut answer, which is why, candidly, I take a little issue that it's being called gamesmanship, because if it was so black and
No,
white.
I understand. I don't think I was kind of thinking it was gamesmanship, but now that I kind of understand what your argument is, I don't think it's gamesmanship. I mean, the way that I hate doing this because I'd much rather rely on case law, but it says for A2, it says in the county of defendant with apostrophe S resident. I'm sorry, let's go to 3. In the county of the defendant's principal office in the state, if the defendant is not a natural person.
Correct.
So it seems to analyze this by defendant.
Correct.
Mhm.
And so if it's by defendant, then venue as to, I'm sorry, McKesson, is that what it's called? What's the name of your client?
Medessa
Medessa.
and Kingpin, yeah.
It would be
Medessa.
Kingpin in that instance.
So as the Medessa venue, that defendant venue would be proper to Hood County. As to, what is the other one again? Kingpin, that one venue would be appropriate to Dallas. It's not how I would normally analyze this.
And Medessa has waived their objection.
Yeah, I don't know if the waiver thing really matters to me.
I respect that, Your Honor. The reason we mentioned it is because if they hadn't waived their objection, it would be a much different calculus if they had raised this issue on their own.
I mean, I would like some additional briefing to see if anyone can find out any cases on point. I mean, I don't really want to make this a case of first impression. Also, if you really cannot find cases, then this might be one. I hate to go through all the way through trial and then we end up having the wrong venue. I think that this might be something you should do in a limited appeal to the Court of Appeals. But I really find it hard to believe there aren't any cases that interpret either of those sections. So at this part, I'm going to defer ruling. And we'll go from there.
When would you like the additional briefing by, Your Honor?
Let's get that by the end of the month. Do we have a trial setting on this?
We do, Your Honor. It's pretty far out, though.
Yeah, it's not until February. Why don't we why don't we do this? Let me go. I don't want to make this just totally open-ended. Let's set this for, how does the second Monday in July, we'll reschedule this for another Zoom hearing.
I'm available, Your Honor.
Will be available.
And I can be available. We're talking July 8th.
Yeah, July 8th.
Yes, I can be available.
Did you just want to reset the whole hearing just to July 8th on this?
Yeah, set it to July 8th at 10:15.
Okay.
All righty. And now when I first read this, it didn't make a whole lot of sense to me, but now it made a little more sense. So
Well, in that case, Your Honor, I apologize that the response I wrote.
yeah, well, it just
Not helpful.
you focused on you seem to be focusing on the fact that the cause of action arose in Dallas County, which I didn't really get, but now that I understand more what your argument is, it makes a little more sense. So try to get me some case law if you can, something, and we'll see you then.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, are you guys ready on this attorney's fees trial?
Your Honor, Blue Razor's ready. We have not received anything from the other side.
Yeah. Yes, Your Honor, we've got our numbers. We've just finished calculating them.
Have you guys shared them?
Well, we have not, because we just finished doing it. Other than we did share the document where we had everything highlighted, but it didn't have the numbers. Based on the objections we have under the case law and statutory law on proper billing, the total amount of objected fees are $517,767. We used the original bill we got because
What
we
you're
wanted to make sure
objecting to 517,000, or that's what it is after reduction?
No, that's what we're objecting to. After reduction, it's 192.33. And those objections are based on block billing, not properly segregating. Obviously, we also contend, as I stated earlier, that under the case law, since they did not comply, that they should not be entitled to anything. But at most, the total fees should be 192.33 divided by the 4 defendants that stood trial. So it would be $47,558.25 per defendant, and we rounded up just to make it easier.
All right. This is what I'm going to do. I'm going to put you guys into a breakout room. I have another hearing I'm going to take. I want you guys to come up with a number, not necessarily that you agree on as to the amount, but that takes out all of I'm going to make it clear enough earlier. I'm not going to remove all the entries just because they're block billed, only removing claims where there was not proper segregation. So I know that's going to take you a little bit. So I'm going to put you into a breakout room. And you guys can talk about it. I will say this, for some reason, and this hasn't happened to me in quite some time, the Dallas County IT keeps on, you know, and I'm going to let you guys just call each other and then sign back onto the Zoom. I'm going to have to restart my computer, which I guess that doesn't necessarily mean it'll end the Zoom. So I'm going to restart my computer, and I'll be back in a few minutes. Let me go ahead and put you guys into a breakout room.
Okay.
So who goes into the breakout room?
For the defendants, it will be me and Dean Drew.
And for the plaintiffs, Whitney Beckworth and Chad Arnett.
This is Mark Stedman, Your Honor. I don't know that I need to be involved in that.
You just want to stay away from the fighting?
Pardon?
Do you want to stay away from the fighting?
I can camp out there. I'll just mute off.
Yeah, it doesn't matter to me. Let me see. Yeah. I think I missed somebody. Does Coleman Proctor go in there?
I don't believe so, Your Honor.
Hannah
No, Judge,
Phillips?
No, Your Honor.
Okay, I hope if I missed somebody, if you haven't gotten an invitation that you needed to, let me know. All right, and I'm going to also put Brianna Beckham. Brianna, are you familiar with Zoom to make sure they can get us back to this room?
Yes.
All right, I'm going to put you into the room as well. All right, and now I'm going to leave this for a second and come right back because my computer has to restart. So let me see. I'm going to put Abigail, you're going to be in charge. Be right back.
Abigail, Chad Arnett needs to be in the breakout room.
All right, I think I got him in.
Thank you.
Oh yeah, while His Honor's gone, guys, I forgot about this until last night, so I might not be the only one, but did everybody send out their emails for the DAYL thing? If not, make sure that you do before tomorrow.
Thank you, Bill.
That's what
Are
I'm
we
here
supposed
for.
to, do we need to post that somewhere?
The
Y'all
DAYL
are still
thing,
on YouTube.
you
Yep.
just
Oh,
send,
yeah,
you
you just
send
have
the
to
email.
say on the spreadsheet that I linked in the intern chat, you just like mark off yes or no. If you can't find it, just tell me and I'll mark it for you.
Yeah, I don't know if people have been forgetting to do it. It just looked like there were a lot missing.
Might be asking an obvious question, but we had a hearing scheduled for 4 o'clock. Is there any rescheduling that we need to do or? amended notice?
I
Oh,
don't,
that's fine. He'll hear it. It's just gonna be
Okay.
a little late.
All right, sorry about that, guys. My computer got shut down by IT. I don't know why they're doing that. Okay, let's go back. We're here on a 4:15 motion to compel. Is that correct?
Good afternoon, Your Honor. Yes, that is correct.
All right, let's proceed. Go ahead and announce, Ms. Kelso, go ahead and announce the name and the cause number on the case.
Rhiannon Kelso for the plaintiff, Sonia Luciano. And the cause number is DC 23-19722.
All right. Opposing counsel?
Coleman Proctor on behalf of the Conti defendants, Spanish Village and Spectrum Realty Group.
Okay. Is that it?
I believe so, Judge. I think I represent the only defendants left in the case, I think.
Okay, let's proceed.
Thank you, Your Honor. Plaintiff has been on a bit of an exhausting quest to get completed required disclosures from the defendant. That is why we are here. After the defendant requested an extension to file their answers and we gave that as a courtesy, they did not meet their disclosure deadline, which was March 7th. Since that time, I have been following up, sending letters, extending deadlines, asking when I'm going to get the information and documents, and that culminated in me finally filing a motion on April 29th. That, of course, was 5 weeks ago, and here we are on June 3rd, and I still do not have complete responses to required disclosures. Specifically, I do not have an insurance policy. I don't have a valid response to subsection B7. The defendants did produce an insurance policy somewhere around mid-April after my continued follow-ups, but it doesn't have any indication that it applies to this case, that it applies to the company who owned the property where my client was shot and killed. It doesn't have a schedule that lists the property location where my client was shot and killed. And again, I have diligently followed up on this. Mr. Proctor has made 3 supplements to the initial disclosures, providing various other information that I was following up on. But we still have this one outstanding issue. A single insurance policy that we cannot determine has any connection to the case. Mr. Proctor has said over and over that he would get the schedules, he would get a list of named insureds, he would get a list of locations that the insurance policy covers. I still don't have that. And additionally, Judge, I would mention they produced a management agreement pertaining to the property where my client was shot and killed. They redacted the sections of the management agreement that refer to the required insurance policy limits. So where it says, you know, the parties to this agreement must maintain insurance in X amount, and they may maintain this amount by umbrella policies or excess policies or what have you. They've redacted that amount. And that management agreement specifically says that the owner of the property must maintain minimum insurance. Again, Judge, the owner of the property has not produced an insurance policy. So what we're asking the court for today is an order requiring all defendants represented by Mr. Proctor to fully respond to required disclosures, subsection B7, and for the amount of time and energy expended on trying to get these documents, drafting a motion, filing a motion, setting it for a hearing, and having to actually attend the hearing today, Judge. We are asking for attorney's fees in the very reasonable amount of $750.
Response?
Thank you, Judge. I don't agree with how that was characterized, the timeline and what's been produced, what hasn't been produced. I have produced the policy. It's the policy that we were hired under. It's the policy that covers everybody. That's what my client says. That's what my carrier says. That's the only policy that I've been informed of that I have.
Does it include the policy limits in it?
It does. And that was not redacted. The management agreement, that refers to having a policy. It's the same limits that our policy has that we did produce.
Did you redact that information?
That was redacted by error, and I told Ms. Kelso, yeah, I'll go ahead and unredact that. What's left, the reason I haven't supplemented with an unredacted copy is I've asked Ms. Kelso, can I just reproduce this with the same dates and swap the management agreement so that we don't have confusion in the parties' document production? I have no problem reproducing it. It's the same policy limits.
Have y'all tried, I mean, so there isn't a schedule that indicates which properties are covered? That's a little strange.
Not that anyone has been able to find or know of. What I did tell Ms. Kelso last week is I found what my clients, I don't know if it's the broker, but Alliant, who did the help schedule the policy, they found a certificate of insurance that does identify Spectrum Realty Group and Spanish Village as being covered by the policy that we produced. In terms of all the other Conti entities.
So did you produce that to Ms. Kelso?
I told Ms. Kelso I'm going to supplement with that once I get confirmation that I'm reading that correctly. I've gone ahead and told her what it shows and what my reading of it is, but I need permission from my client or confirmation. Hey, am I reading this right? These entities.
So Mr. Proctor, let me just cut to the chase because we put a lot of hearings. So you're going to be required to produce that page by this Friday. In addition, you need to provide an unredacted copy of the management, whatever that was, policy that was redacted in error by this Friday. If you do that by Friday, I'm not going to award sanctions. If you don't, then obviously we'll have to look at sanctions.
Understood.
All right. Ms. Kelso, go ahead and get me a order to that effect. The order needs to say that this was heard on June 3rd, 2024 on Zoom, and share that with Mr. Proctor, and I need that before Friday.
Certainly, Your Honor. Thank you, Judge.
All right. You have a great rest of your day.
You too, Judge.
Okay, we have a motion for continuance, I believe, on the Head versus McWilliams case. Are both sides here on that?
We are, Judge.
All right. So this case is pretty old. I'm just wondering why we can't get it to trial.
Judge, this is Brian Stewart on behalf of the plaintiff. This case actually came into our office, and we filed a notice of appearance in March of this year.
Okay.
Obviously, we saw the trial setting and immediately reached out to defense counsel. I don't believe that this is a case where we need a long continuance, but I think just in order to get this case mediated, allow defense counsel to depose a plaintiff, I think that'll take us a few months. As far as I understand it, none of that information has been exchanged before now. No depositions have been taken. I'm not sure exactly what happened before we entered the case, other than it was filed and one answer was filed on behalf of the defendants. But we've talked to defense counsel or the defense counsel that have appeared in the case, and we think we have a path forward, but obviously we needed to get out from under a June 25th trial setting.
I mean, in your motion, it says there's it looks like at least 10 witnesses that you need to depose.
Judge, I don't think that all of those witnesses will need to be deposed. Out of an abundance of caution, when we were trying to come up with the agreed, we put in everything that I think would be necessary for the parties to have both fact witness and expert witness depositions. Again, that isn't really the path that we're on. I think this is a case where we've come in at the 11th hour. We're looking around trying to figure out the best way to get this thing resolved, and we just need a little bit more time to do it.
Plaintiff's counsel?
I am counsel for the defendant, Irving Budget Inn LLC. To date, this is the only defendant who has filed an appearance in this matter, which is one of the issues I believe that has caused this case to stall. The prior plaintiff's counsel made no effort to prosecute the case against any of the three defendants who have been served, but have not filed an appearance in this case. So the witnesses who were identified that depositions would need to occur, I believe that's accurate. Were this case taken through to trial and the case prosecuted against all defendants. However, after conferring with plaintiff's counsel, we are in agreement that we see a path towards resolution and a shorter term where we permitted some additional time to take this towards mediation and complete a shorter list of depositions, including that of plaintiff.
Well, there's 4 plaintiffs, right?
Judge, the plaintiff that defense counsel would need to take would be Deshauna Head.
Okay. I mean, this case is not quite 2 years old. I mean, how much time do you think you need?
Judge, I would say
30 days, 60 days.
I would say 60 days. 90 days would be preferable, but I could live with 60.
All right, let me look at my docket. And you have a mediator. Why haven't y'all mediated with them?
I think it was a matter of trying to figure out, number one, if some discovery needed to take place. We can certainly start that now.
When Mr. Stewart first joined the case, he did request a reprieve on the existing deadlines to permit him to get up to speed. So we did grant those as we filed this agreed motion for continuance, so that we weren't kind of gearing full steam ahead towards mediation with an unprepared party. But we are both committed towards mediating this summer, as he has now been able to review the case and become apprised of the necessary actions.
Has anyone called Mr. Zaleski?
We've been in email correspondence with him.
And what did he say about his availability?
He reached out to determine the availability of both parties. However, with this pending motion, we have not confirmed any scheduling with him at this time.
Rhonda, can you call Mr. Zaleski?
Okay.
Just want to know what his availability is to mediate this. You guys want a half day or a full day for this one?
Judge,
I
I
believe
think
a half day would be sufficient.
I agree.
Really? This is a death case with multiple plaintiffs.
With the limited discovery that has taken place and our ability to negotiate on behalf of only one defendant, that only a half day would be necessary.
Okay.
Thank you for calling Zaleski Mediation. Please leave us a voicemail or for a faster response, email us at
I also have a home number on here. Do you want, well, it's the
Yeah,
same.
try calling him on that.
It's the same. I'm sorry. I can send him an email real quick.
Wait, you said you have a phone number or no phone number?
It's the same as the work number. He's
I
home.
have a mobile number. Let me see if I can reach him.
Okay.
Your call has been forwarded to voicemail. The person you are trying to reach is not available.
Is the number you have 214-352-4491?
No, the one I have is 214-706-9080.
All right, let me try this one.
Oh, we're still on YouTube, giving out his number like that.
either the number.
Check.
Mr. Zaleski, this is Judge Hoffman of the 68th District Court.
Hey, Judge, how's it going?
Good, good. We have a couple parties here on a case that doesn't seem like they've done a whole lot in 2 years on the case, and they want to continue. And so I've told them, and you're the mediator, I guess you've done your job and reached out to them. They have not responded with any dates. So I wanted to get your dates and see if we can't get this mediation scheduled, and so I can figure out when I reset the trial for. So what is your, do you have the ability to check your calendar?
I do. Hold on, give me 1 second. Pop the computer open.
Okay.
Just finished a mediation, so that was great timing.
Perfect, perfect.
Actually, meeting from the office is my office. I mean, meeting from the house is my office. It's still out of electricity.
Oh, no.
Actually, just turned on a few minutes this afternoon. So
they want a half day on a wrongful death case, a shooting case with, no, I'm sorry. Yeah, it's a wrongful death shooting case.
Okay. What do they have? Do they want to try to do it this month, or?
They need to take one deposition beforehand, so probably July.
Okay.
The last 2 weeks of July, preferably.
They requested the last 2 weeks of July, if you have it.
Well, I'm going to be on vacation that week of the 22nd, Coach. So technically, Judge, I can do it anytime. I'm happy to do it. It has to be remote.
Well, I don't want to mess up your vacation. When are you on vacation?
Well, it's the week of the 22nd, but honestly, I end up mediating on vacation.
No, I don't want to be responsible for that. How about the first week of August?
Well, no, the last week, I do have availability. At 2 p.m. on the 29th of July.
All right. How does that sound, guys? 2 p.m. on the 29th of July.
Plaintiff will hold that, Judge.
Clear on our calendar.
No, not hold it. It's going to be scheduled then. Are you available then?
Our office is available, but we would need to confirm with our client.
Well, go ahead and call your client then. I just want to make clear, I'm going to be ordering it on a particular date. And so, Mr. Zaleski, just so you know, I'm going to be ordering it on whatever date we agree on.
Okay, sounds good. And Judge, which case is this?
It is DC 22-14269.
Okay.
Head versus McWilliams.
Okay.
And the attorneys have changed on it, so I want to make sure you have who they are. You have Lauren Martin. Miss Martin, what is your contact information? Oh, I'm sorry, she's calling her client. And the defense counsel, Mr. Stewart, is Brian Stewart. Can you give your contact information to Mr. Zaleski?
Sure, Mr. Zaleski, you can reach me at 210-275-9296.
And what's your email address?
The easiest email is just my name, BRIAN, period, STEWARD @gmail.com.
Did you get that, Mr. Zaleski?
I did.
Okay, and it's with a D, Stewart, not a T.
Okay, I got it. At Gmail.
And Miss Martin?
Yes, Your Honor, I apologize. I was leaving a voicemail for my client.
Okay.
My contact information, is that what you're asking?
Yes, please.
Cell phone, email, what are we giving? I apologize.
Phone and email. Work phone and email.
832-216-1046.